Thank you, and thank you everybody for attending. So I want to talk briefly about the science of vaccine passports, and I'm going to make a bit of a risky attempt to try to bring some understanding about those who oppose them. So I'd like to begin at the beginning of the pandemic, when we were hit by this novel virus that we didn't know anything about. And almost immediately we knew that we realized that our main hope was going to be a vaccine. And we were fortunate. A highly effective vaccine was developed using a novel platform, but then something went wrong. So the real question is, how did we go from here? These are the graphs from the original New England Journal papers of the mRNA vaccines, 95% effectiveness against symptomatic infection. These are remarkable graphs in any kind of study. How do we go from here, which we would have characterized an immunologic moon landing, to here, mass protests, civil unrest, a threat to our civil society? And I really do think it comes down to the science. To understand how policy changes in public health, we have to understand how the science changes in public health. So by now, many of you are indoctrinated in epidemiology, are quite familiar with the idea of the reproduction number. That's the number of individuals infected for every individual who had the infection. The goal of public health policies is to reduce that number less than 1. And vaccination is an important part of that. And the best way, one of the best ways to reduce that reproduction number is through increasing the number of people vaccinated or improving the effectiveness of the vaccine. And to demonstrate how that varies depending on the virus, here's some numbers from the ancestral strain, the Wuhan virus, and the Delta virus. So the Wuhan virus had a reproduction number around 2.5, and the vaccine was highly effective against it, around 95% effectiveness. So the herd immunity threshold for that was around 60-65%. When Delta came along, the reproduction number doubled. The vaccine effectiveness was still good, but it dipped to 80%. But now we basically needed to get almost the entire population vaccinated to reach herd immunity. And this affected how we designed our policies. So when we thought we had a 95% effective vaccine against a moderately infectious virus, voluntary policies could have worked. There was no need to be more aggressive. 60% coverage, we can do that during the flu season through promotion, and that explained a lot of the policy that existed at the time. But then when Delta hit, and we needed to hit vaccination rates greater than 90%, plus the fact that Delta was much more serious, immediately there was a push for mandatory policy. Then we saw that even in places that were otherwise reticent to bring these in, like Ontario and Alberta, that they brought these policies in. But then Omicron complicated the story further. The way the vaccines worked changed. They were no longer primarily providing protection through reducing infection, but through reducing serious illness. And this was a hard fact to communicate to the public. And these are the two different concepts, the two different types of immunity. So we typically think of vaccines as providing sterilizing immunity, protecting against infection, but they also can provide protection in other ways, such as against serious illness. And that's what we saw with Omicron, that we rapidly lost our sterilizing immunity, and we needed boosters to bring it back for periods of time. But you had this continued protective immunity, and this was important because it helped protect the health system from being overloaded. So there was another societal purpose for getting vaccinated. It wasn't to achieve herd immunity, it was to protect our healthcare system. And I just finished 2 weeks on service in the Ottawa hospital, and trust me, we do need that protection. And the evidence is pretty clear. They work in that respect. So this is the evidence for boosters, multiple studies that's showing protection against serious illness, hospitalizations, and deaths. And this is an increasingly important story. We're seeing that pretty good data that these vaccines also protect against long COVID. And this could create quite a significant burden to our health system moving forward. So did the mandates work? The answer actually is yes. Multiple studies have looked at this, and they found studies in Canada found that it increased the pace of vaccination by 66%, probably accounted for 1 million extra Canadians getting vaccinated. And we saw this internationally. So in France, an additional 9 million doses were administered. We saw a benefit in Italy. So they suspect that the vaccine passport saved 4,000 lives in France and actually also boosted GDP by 0.5% and probably protected against a further lockdown. And these benefits were noted in the US, UK, and Germany. And we know vaccines themselves, having people vaccinated and the vaccines themselves save lives. This was an early analysis showing in less than a year, it saved 500,000 lives, but that was looking at direct deaths. This was a model published in Lancet Infectious Diseases that showed that they believe that the vaccines probably saved 20 million lives in the first year of the program with a 2/3 reduction in deaths. This graph below, the darker regions are the ones that most benefited from the vaccines. It's a good story and a bad story. The bad story is it points to inequity in vaccine distribution globally. The good story is Canada was actually one of the countries that benefited the most from the vaccines as far as mortality reduction went. So what's next? Well, we're already seeing the multivalent vaccines coming out. That was the promise of the mRNA platform being able to rapidly iterate. We don't yet know the level of benefit they're going to provide, whether it's mainly on the protective or sterilizing side, but it looks like it's primarily protective immunity. The hope for sterilizing immunity is in the development of mucosal vaccines. There's a lot of work going on underway, but we are seeing continued immune escape and ongoing challenges from this virus. Okay, now for the riskier part of the talk, trying to attempt to understand the protests. And we have this enormously beneficial intervention, so why were people so upset? Now, as a proviso, I'm pro-vaccine passport. This is a paper actually in 2016 where we described the development of a digital vaccine passport. And at the outset of the pandemic, I was calling for it, and even Fox News ran our story. So Fox News was for vaccine passports before they were against them. And to further give me credibility, the anti-vaxxers think I'm behind this whole thing. I haven't gotten a penny from the federal government, and I wasn't part of ArriveCan, but they believe that I'm part of a conspiracy with Bill Gates. But that being said, objectively looking at this, and this is hard, I'm not trying to be critical, but here are some things we could have done better. Kind of could have predicted that we were going to need vaccine passports, and preparation for this could have begun earlier, perhaps up a year earlier, as opposed to when the science forced us to do it. As the science changed, we could have changed the requirements for vaccine passports. Easier said than done, but as we move from sterilizing to protective immunity, changes in policies could have been perhaps implemented more quickly. And better communication around how vaccines work. This idea of both sterilizing and protective immunity could have helped the public understand. So, as I've been looking at this, how could this simple act of getting vaccinated result in such a disruption to society and cause so much ire amongst the population? And I'm sort of viewing that the vaccination may have been a metaphor for other angst people were feeling. And it was largely blue-collar individuals who were upset by these mandates, and it could have come to represent the vaccine passports were a very tangible representation of them being locked out of society if they chose not to be vaccinated. but I suspect many of these people felt that they were locked out of society in other ways. They didn't have some of the same opportunities. Those of us who are better off have, their children may not have the same opportunities, but the vaccines passports were very tangible representations of that. And then I think that's why it really did trigger them. And, you know, maybe I'm being a little optimistic or perhaps naive, but I think, you know, if we're trying to address these challenges of disinformation and skepticism of our authorities, I think addressing the challenges of social mobility and opportunity are going to be a really important step. And I think if we take that lens, we may have a more success in communicating our public health visions. And I will stop there and thank you for your time.
Thank you very much. More than perfect timing. So we'll continue with Bryan Thomas. Bryan is a senior research fellow with the Center for Law Policy, Health Law and Policy and Ethics, and also adjunct professor at the Common Law section of the Faculty of Law, University of Ottawa. His research spans a wide range of topics, including Canadian and comparative health law, policy, health rights litigation, long-term care, global health law, and the role of religions, arguments in legal and political discourse. His presentation is entitled Human Rights Implications of Vaccine Passports. The floor is yours, Bryan.
Thank you. Thanks for being here and thanks for having me. It's an honor to speak with this esteemed panel. So I'm going to talk about give a kind of broad overview of the human rights concerns or charter rights concerns that were raised in connection with vaccine passports. So I'm going to walk through those, and I guess the kind of direction I'm going with this is I actually think these are all fairly weak arguments. I don't think there was ever a serious, I don't think that any of these arguments are terribly compelling. And so I want to end with some thoughts about, end my talk with some thoughts about what went wrong in terms of the legal discourse on this topic. And I guess it'll connect with what Kumanan has said, because I think maybe the legal commentariat didn't do as good a job as they could of communicating that these were not as grave, that the sort of human rights implications of this technology were not as grave as some were saying. And so I'll get to that towards the end of the talk. So as Kumanan explained, the kind of general rationale for vaccine passports is to sort of allow the safe reopening of society. We've had these lockdown restrictions, we've had closure of restaurants and gyms and so on. And with the arrival of the vaccines in I guess in late 2020, late 2021, there's this realization, well, we can, if we sort of gate access to these indoor locations for people who are vaccinated, then that will either, as the science evolved, initially the thought was this will slow transmission. Later, the thought was this will at least prevent hospitalizations because people who've been vaccinated are not at high risk of requiring hospitalization. And of course, the end game there is to avoid hospital overload in part. So that was the rationale. And as Kumanan said, the kind of shifting explanation of that between sterilizing and protective immunity is, it kind of changes the logic of the proportionality analysis and so on. It changes some of the ethical considerations of this. So I think that was also a complicating factor in legal discourse, right? The kind of a shift away from a kind of protecting other people towards a more paternalistic lens, where you're trying to protect people from themselves, protect the unvaccinated from themselves, rather than protecting them from transmitting the disease. That's, for a lot of people, that changes the kind of moral calculus and maybe even the legal calculus a little bit, because we have we're less confident about paternalistic interventions in health policy. Okay, so going on to the meat of this. So just a quick overview. So what rights are engaged by vaccine passport regimes? And one of my gripes about this, I've been researching this topic for a year and a half now. One of my gripes about it is that none of the critics of this technology have, to my knowledge, come out with a really cogent and clear statement of their, like, sort of making their case with legal arguments and citations and so on. So we kind of have to kind of infer this from letters and op-eds and sort of informal forms of legal communication that are public communication that are, you've got to kind of guess at what people were thinking in terms of their concerns about this. But anyway, so the concerns, there's kind of four broad categories of concerns that I think have been raised. The first one is that is this concern that vaccine passports interfere with the liberty and security of the person. The second concern is that vaccine passports interfere with freedom of religion and freedom of conscience. The third is that vaccine passports create inequality and a two-tier society. And then the fourth basket of concerns relates to health information privacy. So I'm just going to go through these quickly in turn. So this issue of liberty and security of the person, this is section 7 of the charter. The concern has been that if we create a vaccine passport regime that is so ubiquitous that you really just can't resume your life unless you've been vaccinated, then it looks like this kind of intrudes on patient autonomy. It looks like the more and more pervasive and ubiquitous this requirement becomes, the less and less choice you have in the matter of whether to be vaccinated, right? So this is and certainly Canadian law does take patient autonomy very seriously. You basically, if you're an adult of sound mind, you cannot be forced to take a medical intervention, even if its benefits to you are unequivocal. Now, I think the critical problem with this concern, or with this notion that the right to liberty and security of the person is violated by vaccine passport requirements, is that the courts have been quite clear that sort of non-essential activities, like the kinds of things that were gated by vaccine passports, things like going to the gym or going to a movie or dining indoor at a restaurant, these kinds of things are actually not meant to be protected under Section 7, and the rationale being that this would just make society ungovernable, right? So I've got this quote here from Michael OBrien, which was a case about recreational marijuana use. The court says, the Constitution cannot be stretched to afford protection to whatever activity an individual chooses to define as central to his or her lifestyle. One individual chooses to smoke marijuana, another has an obsessive interest in golf, the third is addicted to gambling. The appellate Kane invokes a taste for fatty foods. A society that extended constitutional protection to any and all such lifestyles would be ungovernable. So I think that this is kind of the direction this is the reason why this argument about vaccine passports doesn't work, is that the kinds of things that were being gated by vaccine passports just do not rise to the level of constitutional protection, and I couldn't see the courts sort of buying this argument. So I guess there's also the concern that if in other contexts where people are being required to be vaccinated in order to go to work, then you have a kind of economic interest. But the courts have also been quite clear that Section 7 does not protect economic interests. So it's really hard to see an argument here that vaccine passports are coercive in a way that's impermissible, that would even go to a Section 1 proportionality analysis. I think this whole line of argument kind of fails at the first hurdle. So I'll move on from that. Next is the category of freedom of religion. This might be the most plausible area where vaccine passports run into trouble, right? So the Canadian Supreme Court has in 2004 decision sort of set up the current test for freedom of religion. It is a very expansive and very generous test of what's protected under the Charter's protection of freedom of religion. So what the claimant has to show in these contexts is that the conduct, so in this case, not getting vaccinated, has some nexus with religion. So that's a pretty vague, open-ended thing, right? It just has to have some connection whatsoever, like just a non-trivial connection. It has to. A second test is that the religious beliefs have to be sincere. So I presume if you were going to litigate this, you might have provided some explanation as to your thinking on the topic, but you do not have to claim that your religious views reflect the views of your church or your scriptures or anything. These can be absolutely idiosyncratic beliefs, right? In fact, the claimant in this case was claiming that he wanted to have a personal sukkah, which is kind of a hut that Jewish people use in one of their holidays, that he wanted to have one on the patio of his condominium, and his rabbis came to the court and said, this is actually not required by our religion, but the court nevertheless said, well, it's important to this guy, so this is going to be protected under freedom of religion. So people could have, all that to say that people could have idiosyncratic ideas about vaccines that are not actually supported by any of the major religions, and in theory, those should receive the protection of under freedom of religion. So we have this very expansive, very expansive test to sort of get into the proportionality stage of analysis in talking about this issue. And then it's hard to say what would happen if this actually got to a Section 1 claim, someone objecting to a vaccination passport regime because of their religion. Certainly, I think that vaccine passports are not a trivial interference, and not being able to go to the gym and not being able to go to movies and go about your life, that's not trivial. So I think this would get through the infringement stage, but the question would be at Section 1, I think, how the courts would go about this, and Carissima Mathen is going to talk more about this in her talk, so I won't go on too long, but I think there's multiple ways the courts could go with this. One way they could go is to say they have, in some cases, there's a case involving Hutterites in Alberta who who objected to, who they read the passages in the Bible about not creating graven images. They understand that as meaning that they shouldn't be photographed, and so they challenged the laws requiring a photograph in your driver's license, and they ultimately lost to the Supreme Court, and with the court saying, you know, this driver's licensing scheme just has to have integrity. We can't have a bunch of exceptions to it. Everybody driving needs to have a photo ID. So that I think that you can see how that an analogy to that might be drawn in the vaccine passport system. You know, we just can't start carving out exceptions and trying to vet everybody's idiosyncratic religious beliefs and so on. So I think that might be the way that the courts would go. But the other way they could go is they could have created some, or demanded the government create some bureaucracy to have people submit paperwork, like have some, it could be even an onerous process where people can try to prove their religious, the sincerity of their religious beliefs, and then be issued a vaccine passport on that basis, right? So in other words, you could have carved out little accommodations here. This wasn't an unfixable problem. It was a kind of, generally the way that religious freedom claims are treated is not by overturning the law, it's by, or the policy, it's by carving out exceptions for the few religious people who object, right? So this, and all that to say that there was in the freedom of religion context, there was nothing fatal to the idea of vaccine passports, in as far as I can tell. Moving on to, I think this is actually more the heart of the matter, is freedom of conscience claims, right? So people who think that their attitudes about vaccination rise to the level of this is a kind of philosophical outlook for them, and they feel like they're being coerced against their moral integrity is being compromised when they're being pressured to get vaccinated. And this is an area where the Canadian jurisprudence is really underdeveloped. There's very scant charter jurisprudence on freedom of conscience, and the kind of governing paradigm is one from an early 80s case called Edwards Books, where the court kind of muses about freedom of conscience and says, basically, the type of thing we're trying to protect under freedom of conscience is, let me just quote here, these are values that are comprehensive value systems, they call them, or profoundly personal beliefs that govern one's perception of oneself, humankind, and nature. So you're getting this, the court has in mind this kind of, what the court wants to protect in terms of freedom of conscience are these kind of sort of quasi-religious views, right? Like the views, someone who has a kind of a moral view that's kind of knitted up with their view of the universe and with their view of humankind in some kind of rich way, like you get in the scriptural text. Whereas someone who, in the paper, I cite this case, Locke from Alberta, where a guy came before the court making a freedom of conscience claim saying, I just don't believe the science of seatbelt safety, right? So I want to be exempted from seatbelt laws. And the court looked at that and said, this is nowhere near close enough to this does not fit the mold of a comprehensive worldview. These are not profoundly personal beliefs. These are just your particular judgments about a particular issue in public policy of whether seatbelts make sense, right? And we're not going to protect that. And this probably goes back to the point under Section 7 of just, this would just be ungovernable. You know, we can't just allow every individual to second guess the wisdom of lawmakers, you know, empirical calculations about the wisdom of the science of seatbelts. So this is just a no-go direction for freedom of conscience. This distinction between categorical and particular moral judgments is one that's has a long-standing kind of history in U.S. jurisprudence. This was used to differentiate people who were principled pacifists, like Quakers, from people who just had a problem with the Vietnam War and who were seeking exemptions from the draft of serving in the Vietnam War in particular. And the courts would say, if you have a categorical problem with war, then we'll give you an exemption. If your problem is just with the Vietnam War, then that's a question that belongs in the political realm, and it's been decided for you. You don't get to second guess it and get an exemption if you disagree with the wisdom of it. So, I think I'm not crazy about this. I wonder about this. I think there are sort of, I think this is on its face, this is kind of unfair to non-religious people, having as someone with secular morality, having to fit your moral sensibilities into the mold of a kind of quasi-religious viewpoint. I think that's kind of unfair, and we could talk about how to think about that. But anyway, all that to say that I don't think there's a freedom of conscience claim here either. How am I doing on time?
4 minutes.
Okay. So the next category here is this is Doug Ford's line here, that creating a vaccine passport scheme would create a two-tier society. And there's just a lot of problems with this argument too. I mean, the critical question, I think, is, you know, we normally assume that if you want to make a claim, an equality claim on the charter, you have to fall into something like an enumerated or analogous ground. So you have to cite something, maybe your race or your gender, or some analogous ground like your sexual orientation. But the kind of tracking guide here is that you're looking for some immutable trait that you're being discriminated on the basis of. And the problem vaccine passport, with vaccine hesitancy, is that that's really not an immutable trait. In fact, it's a trait that the government is very heavily invested in changing in people, right? So, we can turn people into, part of the point of having vaccine passport regimes is to incentivize people to get vaccinated. So it doesn't make sense to think of this as an immutable trait or that it's analogous to gender and sex and so on. Another problem with this equality argument is that the equality jurisprudence is often concerned with sort of policies that stigmatize people as being sort of second class citizens, or as being less deserving of dignity and concern and so on. And it's clear that a vaccine passport regime does not do that, because it's actually paternalistic. It's precisely a concern with the well-being of the unvaccinated that motivates it. So to describe this as being sort of undignified in some ways is I think quite misleading. And finally, I think this is maybe the most important point, is that and it gets missed often, is that the alternative to a vaccine passport regime is not some open society where everybody gets to go back into restaurants and into movie theaters. The alternative was a complete lockdown of these things for everybody, right? So you hear people telling these stories about how, well, if we have vaccine passport regimes, then homeless people won't be able to go and warm up in cafes. And it's like, okay, if we don't have vaccine passport regimes, people will not be able to go and warm up in cafes. So this is a kind of non-argument or this is a bit of nonsense that I think has lingered in our discourse. Okay, so shifting to privacy rights, I'm not going to talk much about privacy rights because there's other panelists on this, but this might have been I think this might have been one of the most inflammatory kind of angles of this, people treating this as though this is the commencement of a kind of totalitarian state, right? And the people, otherwise responsible people were using this allusions to, this show me your papers, a kind of allusion to Nazism and so on. And, I have a colleague at University of Manitoba who, an ethicist who, for the first time in his life, was receiving death threats for his defense of vaccine passports, because people were so up in arms over this insanely irresponsible rhetoric around this topic, right? So, but on the legal question, I think there's very little likelihood that the courts would ever overturn or even challenge vaccine passports on the basis of privacy rights, at least in the way that they were designed in Canada, because so little information was collected, no information was retained. There was nothing in an apparatus, nothing approaching a kind of apparatus of state surveillance at work here. If anything, the whole thing was kind of half-assed and like kind of inept. It would have been better if we did have more kind of mass tracking. There's potential for great benefit to public health in that sense. But so this I just find this rhetoric, especially in retrospect, is kind of appalling. So just in terms of conclusions, I guess, as I was saying at the outset, doing kind of postmortem on conversations about this, I kind of reflect on my own. I was doing media interviews and so on, and I was kind of thinking about the kind of incentives of someone as someone who studied the issues and who's invited to go on the news and talk about it. And you have this tendency to want to kind of flag all of the legal issues, and approach it kind of like a law exam and demonstrate that you haven't missed anything. And I think that what winds up happening is that the newspaper reporting just sort of catalogs all the potential issues. It never gets quite to the fact that none of these issues are really that serious, that most of these wouldn't even make it past the infringement stage. None of them, I think, would survive at the Section 1 stage. Like this was a sort of tempest in a teapot that really stalled our progress in terms of designing a vaccine passport regime for months and months and months, when we knew it was going to be inevitable. And then we had to scramble the last minute, and we implemented this system that was, it was take the piece of paper you got when you got vaccinated and show it to restaurateurs. I mean, a totally, a system that's ripe for fraud, a system that's, that doesn't allow us to do like sort of public health tracking or any of the things we might want to do with a vaccine passport regime. And it's because we wasted all this time dickering with silly counter arguments that should have been resolved within the first month of contemplating this technology, as far as I'm concerned. So I'll end with that. Oh, sorry.
Thank you. Was perfect timing, Bryan. Like
Okay.
3 seconds late or something like that.
Good.
So we continue the discussion on constitutional issues with Carissima Mathen. Carissima is a law professor here at the common law session of the University of Ottawa. She teaches constitutional law, criminal law, and advanced seminars in constitutional law. She has a long experience in constitutional litigation. She was the director of the litigation for the Women Legal Education Action Fund from 94 to 2001, and really participated in some key cases of the Supreme Court. She's now the editor of the leading case book in constitutional law, Canadian constitutional law, already reaching the 6th edition and forthcoming. So free advertisement for your new book, Carissima. And her presentation today is on rights protection and moving targets in a pandemic age. So the cloud is yours.
Thank you so much. So I had a good 2.5 years, but COVID finally caught up with me. So I'm so sorry that I can't be there with you all. And I ask your indulgence as I'm obviously not quite at 100%. So I'm going to talk about how a religious claim to refuse vaccination is being analyzed and what we might expect in the Canadian context. How do we characterize vaccine refusals? Justification. I have my comments today are a little less complete, and then some of the lessons I've learned, and then if I have time, I had a little teaser for this interesting development that we're seeing from the province of Alberta with respect to the human rights regime and vaccination. So the chapter that I'm drafting relies on a number of sources, both in and outside Canada. I don't make any claim to comprehensiveness for this set of sources. There are few reported cases dealing with vaccines in particular. So I draw analogies with other religious claims, in particular restrictions on gatherings, acknowledging that these are not perfect. So this is one of literally thousands of the references you can see to the significance of freedom of religion in various state instruments, constitutional litigation, policy statements, etc. And so it surely doesn't come as a surprise that numerous dozens, hundreds of international and domestic authorities have stressed that when they address COVID-19, state actors must seriously consider any impact on freedom of religion. And recommendations made in that regard included indicating the measures taken to protect religious minorities from discrimination, itemizing so-called special sensitivities around religious beliefs, being very cautious in the suspension of civil liberties, and ensuring that any rights restrictions are narrowly defined and proportional. So a primary issue in freedom of religion, of course, always relates to its scope. Does it, for example, include acts that cause harm to others? Must a practice be recognized by specific religious denominations? As Bryan has already alluded to, Canadian courts have, for the last decade and a half, defined religious freedom exceptionally broadly. So to establish a breach of one's freedom of religion, the claimant need only show that they sincerely hold a belief or practice that has a nexus with religion, and the impugned measure interferes with their ability to act in accordance with that belief in a manner that is more than trivial. So a refusal to a refusal to accept a vaccine must be religious in nature to get over the threshold question here. The Canadian authorities who have weighed in have displayed some skepticism about that point. So here we have a quote from the Ontario Human Rights Commission issued relatively early on that states that while receiving a vaccine is a voluntary decision, a person who chooses not to be vaccinated based on a personal preference does not have the right to accommodation under the code. The Commission also stressed that personal preferences or singular beliefs do not amount to a creed for the purpose of the code. That sort of tracks some of the discussion previously around conscience. And we see similar policy statements from human rights commissions in New Brunswick, Alberta, Newfoundland and Labrador, Nova Scotia, and Yukon Territory. So clearly, merely asserting a religious belief is not going to be sufficient to grant someone an exemption from a vaccine mandate. There must be a demonstrable link to the claimant's religious worldview, and critically, the belief cannot be a political position operating in disguise. The lack of mainstream theological opposition to vaccines has actually been noted in judgments, in particular in some foreign legal judgments in systems that have some comparative value with Canada. So in a case I read called Hussein, the English High Court of Justice considered statements prepared by the British Board of Scholars and Imams about the obligation on Muslim males to attend special Friday prayers. And that board advised that any ban on public gatherings would essentially take precedence over that obligation. The claimants obviously disagreed, but the court found that this was a legitimate difference of opinion that was relevant to the question of justification. In its view, achieving a fair balance would recognize the indisputable point that the claimant's beliefs as to communal Friday prayer in current circumstances are not beliefs shared by all Muslims. Now, that would be unquestionably a weaker position in Canadian law, but what we see as its correlative in Canada is that adjudicators have been prepared to, robustly interrogate the link between particular beliefs about COVID measures and religion. So in one case, a man complained against a store's mask policy, and he reasoned that because God created me in his own image, and if he cannot see that image because it is covered with a face mask, I have committed sacrilege. The Human Rights Tribunal found that he had failed to explain how that belief is tied to any particular religion, how it is religious in nature, or that the requirement to cover one's face restricted his ability to practice his religious faith. In another case, the Ontario Divisional Court, while it did not have to reach the issue, in Oberter's statements, it expressed skepticism. It cast doubt on a common attack on COVID vaccines, which is that they are derived from fetal cell tissue taken from selective abortions. So the presumption, or the tendency that at least appears to be taking some root, is that anti-vaccine belief is not necessarily related to religion. Now, to be sure, this is in some tension with the predominant subjective approach to religious belief in Canadian law. And it is possible that a perhaps more coherent claimant may be able to articulate a cogent link between such views and their religious worldview. But it may be that the attempts to link vaccine denialism to protected religious freedom will be a step too far for Canadian courts, and they will either tweak the test in Absalom, the 2004 case that was mentioned earlier, or they may be prepared to find that such claims lack credibility, i.e. are not sincere. Under the Canadian Charter, once someone establishes a prima facie breach of a right, such as freedom of religion, the state can try to justify that breach under Section 1 of the Charter as a reasonable limit. It will have to show that the challenged law has a pressing and substantial objective, is rationally connected in its design to meet that objective, violates charter rights to the least extent possible, and operates in a manner that is overall proportional between the measure's salutary and deleterious effects. And this approach to justification finds ready comparators in foreign jurisdictions. The common questions in this context would include what threat was posed by COVID-19, what evidence and processes were relied upon by the state in making its decisions, how agile was a government in responding to new information, and what consideration was given to the specific religious beliefs in question. So to see how courts have dealt with this question, with this issue of justification, I looked at cases not only from Canada, but from diverse jurisdictions, including Trinidad and Tobago, New Zealand, England and Wales, Scotland, the United States, and as I said, a number of Canadian provinces. Virtually all the cases recognize that combating COVID was or is a pressing and substantial objective or its legal equivalent, that it presents truly exceptional circumstances and is a genuine and present danger to the health and well-being of the general population. Even more skeptical judges, such as some of those on SCOTUS, the United States Supreme Court, have acknowledged the state's compelling interest in managing COVID-19. Courts have also rejected broadside attacks on COVID rules, especially when linked to dubious scientific assertions. So in the case noted here, the appellants contended that the province of Manitoba was relying, quote, on unconvincing science that did more harm than good, end quote. And the court utterly rejected that, stating there is nothing that would persuasively suggest that deaths from COVID-19 are not real, that positive PCR cases of COVID-19 are not real, that Manitoba's modeling projections were proven incorrect, and or that in making the difficult decisions required of them, these public health officials failed to properly balance collateral effects. A somewhat less provocative argument is that any restrictions are not rationally connected to the objective because the scientific basis for them was just unavailable, is not as certain. Here, courts have stressed the need for judges to not second guess the information available at the time, and they have explicitly, in some cases, borrowed from the precautionary principle to state that, quote, to wait for certainty is to wait too long, end quote. And at least one court has rejected the argument that the emergence of the Omicron variant significantly changes the analysis, reasoning that there remains a significant public health benefit to these measures sufficient to establish a connection, a rational design. Some courts, though, have considered whether a state authority fails to explain distinctions between religious and other kinds of activities in the COVID measures. So this is especially acute in cases dealing with limits on gatherings. So limits on religious gatherings that were not replicated in other public health measures with respect to other activity have been fatal to state actors in several proceedings in the United States, where a majority of justices concluded that such treatment constituted targeting of religious groups that is prohibited under the First Amendment. Similar reasoning appears in a Scottish case called Philip, where the court said, as soon as the authorities allow some exceptions to the stay-at-home rule and the corresponding requirements to close premises and restrict activities, it then falls on them to justify why other exceptions are not allowed. The answer given was to say that choices had to be made, that it was important that the criminal justice system in this case continue to operate, and that the respondents were entitled to leave the decision as to whether to leave those decisions to the state. I accept all of this. This is the judge speaking, of course, but the point, it seems to me, is that there is at the very least an implicit acceptance by the state that meeting indoors can be safe if suitable mitigation measures can be adopted. Now, I should note that in other cases, the courts have found that such distinctions did not destroy the government's case, reasoning that a level of deference is required. And of course, there is, it's not a perfect comparison when you're speaking of something like a vaccine mandate, which is meant to be universally applied, as opposed to more fine-tuned policy choices around the kinds of public activities that can go on. So just some concluding thoughts at this point. Intriguingly, tying vaccine hesitancy or refusal to religious beliefs is just not going to be straightforward. I see intriguingly mostly from a Canadian perspective. As Bryan has noted, there is a dubious quality to many of the arguments that are presented. And it may be that the courts will require a more exacting explanation of what the religious belief is. And adjudicators appear to be concerned about the fact that religious freedom may be easily invoked as a shield for what are in essence political positions. The tendency to refer to vaccine supportive stances in religious organizations may present at least some complications or a different aspect to a long-standing tenet in Canadian religious freedom law that we just don't consider. We consider the individual belief in this silo divorced from any broader context of the community in which that person lives. Second, I think that public measures against COVID will likely continue to be seen as a pressing and substantial objective. I would assume that this would last for as long as the pandemic officially does. I didn't have time to note this specifically in the previous slides, but I did want to say that one thing we are seeing in the case law is a shift from the objective being preventing harm to individuals to preventing an overload on the public healthcare system. And I'm confident that that would be accepted as a valid objective, and it may mitigate any chink in the armor posed by the fact that vaccination does not provide as effective a barrier against transmission as we once thought. Now, that doesn't mean that vaccine mandates are bulletproof. It's in recent months, notwithstanding evidence that COVID is once again on the rise in the community, many governments have greatly relaxed public health measures or removed them altogether. So that suggests that they no longer view the pandemic as a public health emergency, or at least they're not treating it that way any longer. And so we do have to be sensitive to the effect that that may have on the justificatory analysis for vaccine mandates that continue to be in place. I realize this is academic in the current moment, but I did just want to point that out. If I'm just going to take 30 seconds to say a new development is that in the province of Alberta is that the new premier has decided to grab the bull by the horns, as it were, to amend the human rights code in that province to make it a prohibited ground of discrimination to refuse services, accommodation, employment to those who refuse to be vaccinated. It was seen that this was a bit of a Mack truck policy. And so in recent days, she helpfully clarified that this is only going to apply to the COVID-19 suite of vaccines. And I think that's actually perhaps a fatal decision on her part, because I think this could be one of the rare instances where that decision could actually be challenged as arbitrary, and therefore will significantly weaken that. If that were to go forward, I think that it would perhaps face a daunting struggle in the courts, but there's much more to say.
She's frozen up.
Just for the record, it was not me that cut her.
Sorry about that. I hope I'm back now.
Thank you, Carissima. We'll continue with Jeff King. He's a law professor at University College London. Jeff's research interests include UK and comparative public law, including international law, constitutional theory, and social legal studies. His work particularly focus on the relationship between public law, democracy, and social policy. He's currently working on the use and abuse of delegate powers, comparative legal response to COVID-19, and he's writing a book on the social dimension of the rule of law, and also presenting today on mobility restrictions, human rights, and epidemiological efficacy.
Thank you very much for that introduction. I'll just add that it's lovely to be back in Ottawa. I was born and raised in this city, and I attended this university when I studied philosophy in the early 90s. So it's a real pleasure to be back. It's a beautiful city. So I'll be speaking not about vaccine mandates in particular, although I have spent a lot of time working on that issue, but rather mobility restrictions in general. I consider vaccine mandates, and in particular passports for getting across boundaries, to fall into the category of mobility restrictions. And I'd like to look at the relationship between those and human rights, and in particular legal challenges to them. What I'd like to do over the next 15 minutes is to look at some skepticism about the relationship between mobility restrictions and human rights, and to debunk that skepticism in the same kind of vein as Bryan has done, I should add. So let me begin with the problem. Oh, right, sorry. Here we go. The problem is, do public health interventions and mobility restrictions among them violate liberty rights? So let's take a few examples. We have a senior judge in the UK, Lord Sumption, Jonathan Sumption, who refers to lockdown provisions as creating a totalitarian society in a very public lecture that lots of lawyers attended at Cambridge University. You have a distinguished barrister, Adam Wagner, who is in the news all the time, publishing a book called Emergency State. And another colleague and friend, Adam is a friend, another colleague and friend, Tom Hickman, has also described the reaction of the state as being highly problematic constitutionally. My view is that these kinds of contributions tend to contribute to the view that there is a tension between mobility restrictions and human rights, one that requires urgent explanation. Somewhat more concerning is that a huge percentage of the public believes that lockdowns violated at least, so we're looking at 83% believe that the lockdown violated at least one of 9 rights ideas. This had to be explained in a way suitable for public discussion. And 57% of those polled believe that the majority of 9 rights were violated. This is a forthcoming piece of work. I think it's under review at the OJLS, but if anyone is interested in seeing this fascinating article, do reach out and I can send it to you in draft. However, amongst those persons, only 32% had the view that the lockdown constituted an unacceptable violation of human rights. Now, this suggests then another kind of problem, which is that the public may think it's okay to violate human rights in certain circumstances. Now, the point that I want to make in the time that remains is that these are misguided views. They do not follow from the theory of human rights. They don't follow from the theory of constitutional rights. And they do not sound in the legal culture of any jurisdiction that I'm familiar with. Let me get on to that. So I'll start with a theory of human rights. And I want to start with a particularly liberal or libertarian conception of human rights. So we'll take the strictest one that I know, which is based on the harm principle that's set out in the work of John Stuart Mill, that the sole end for which mankind is warranted interfering with the liberty of another is to protect harm to others, protect them. Harm to self is never an acceptable justification, Mill argues. Well, the simple issue here is that transmission is harm to others. We'll come on to paternalistic interventions in a moment. Now, some think that the proportionality structure of constitutional rights litigation suggests that, it's easy to explain public health interventions on that model. What about a stricter conception of rights, a deontological or rule-based conception of absolute rights that is more along the lines of a rights as trumped model? And some people who've studied jurisprudence will be familiar with the work of Ronald Dworkin, who's the most famous exponent of that kind of view, that rights are trumps over competing public policy arguments. How do mobility restrictions figure in that type of scenario? Well, let's take a closer look at what Dworkin actually says. He distinguishes between abstract rights and concrete rights. So here's his definition of abstract rights. So he's recognizing here that a right to liberty or a right to equality is an abstract claim. For it to be applied in a concrete situation, you need to examine the rest of the social circumstances. So concrete rights are those that are more precisely defined to express the kind of weight that they have against other political claims. So even within the context of a pure rights as trumps model, like the one advocated by Dworkin, you can easily see how you can say on the one hand that there's an abstract right to liberty, but on the other that there's no concrete right to be free of a vaccine mandate or a stay-at-home order, so on. Now that's the liberal view of human rights. And I should say neoliberal, although Ronald Dworkin was no neoliberal, but I've tried to present the version of a rights theory that is the most hostile to any form of social intervention. On the correct view of human rights, of course, we can see in the International Covenant on Economic, Social, and Cultural Rights that the fulfillment of the right to health through preventative action to control epidemics is clearly outlined. And I should add that this provision and many others in other areas of international law have been cited repeatedly in the courts in jurisdictions I've seen where there have been challenges to lockdowns. And essentially courts have said these states are giving effect to their international obligations to protect the right to health, among other social rights. And in the context of mandatory COVID-19 vaccination, and as we've just discussed, the project that I'm involved with, Lex Atlas, we put together principles on mandatory vaccination. These were summarized in this very short piece here for the Lancet, in which we argued there is no in-principle compatibility between human rights and mandatory vaccination policies. That's not to say that they wouldn't be right in some contexts. Right, so let's very briefly talk about the theory of constitutional rights. So that's human rights. But what about the fact that the global model of constitutional rights at the moment is one in which courts recognize that rights are infringed, but that infringements can be justified under a proportionality test. Okay, I think it's important to get this language straight. It means that rights are not violated unless they are infringed unjustifiably. Even yesterday, there was a slide on screen which said that a court found that the rights had been violated, but the violation was justified. I think that it's not mere rhetoric to attach a serious consequence to the word violation. It carries weight. It speaks to the peremptory force of rights. It's wrong to say that it's okay to violate rights. This language helps us to avoid this. I wonder if in that public polling we saw in the article I had indicated, had we tutored the respondents to distinguish between infringements and violations, those numbers would have come out the same way. So under this approach, and as we've seen in the presentation that Carissima had given, courts are fairly permissive about what constitutes an infringement, subject to what Bryan has showed, and they're more searching in the justifications analysis. Although with the question of vaccine mandates, there have been a lot of spurious claims to try to get human rights arguments in play at the infringement stage. This is what Bryan has showed. In the international jurisprudence that I've looked at, the courts are fairly quick to recognize a mobility restriction will engage right to liberty, among other rights. Now, you might wonder, are courts that are engaged in this kind of balancing process? Let's just take our skeptical person in the audience. There might not be one here right now, but somebody might say, well, aren't these courts just negating the real value of human rights by adopting the proportionality test in this way, which allows balancing? There is no evidence that constitutional courts that vigorously apply the proportionality framework are any less activist than any other high court. The Israeli and German Federal Constitutional Court are among the most activist in the world, and they apply that framework quite vigorously. So I don't see any evidence of that. Now, what about evidence? So looking to comparative litigation, I'll mention that I've been engaged also with Colleen and Bryan on this massive project, Lex Atlas COVID-19. We've produced the Oxford Compendium of National Legal Responses to COVID-19. We have country reports that cover these topics. Every single report is structured in exactly the same way. They've been edited incredibly carefully to make sure that the same author guidance code, which is about 8,000 words long, has been addressed. So there are dozens and dozens of questions. They're all answered in the same part of every report. So you can compare. Lockdowns or stay-at-home orders are addressed in part 4A1 in every single report. So you can compare. At the moment, there are over 40 countries included. We're expecting 50, and they're written by teams of local scholars. And the quality of the reports is really outstanding. Now, what's emerged from this project is that what I'm calling frontal legal challenges that allege a basic incompatibility between liberty and a general lockdown or mobility restriction have been rejected in every case that I have seen, and including these countries here, which I studied a bit more carefully in preparation for this talk today. What you sometimes have are procedural challenges that will go for the legality or clarity of a particular provision. For instance, in Austria and New Zealand, measures were declared to have violated rights on those grounds. In Austria, that declaration was inconsequential. In New Zealand, I think it was left as a declaration. And sometimes on federalism grounds. But here too, the consequences are not earth-shattering in those findings. Okay, so what I want to do over in the time that remains is to look at, I want to look at certain legal issues that occur regularly in some of that jurisprudence and to try to show why in applying for what I'll be looking at as the proportionality test, courts have not been regularly challenging and striking down restrictions, mobility restrictions, and neither should they. So we'll start with the proportionality test, legitimate aim or a compelling public interest. I'm not going to speak in detail about this. As Carissima has said, every case I've looked at accepts protection of public health as a legitimate aim. It was an open question of whether a paternalistic intervention would pass this test. I've not seen that judged legally, but what I have seen judicially determined is that protection of the health service is a legitimate public aim. So insofar as arguments for vaccine mandates go in that direction, they'll find some support. Rational connection and suitability, I'll speak about, minimal impairment and fair balance. Now, laid over all of these things is the question about judicial restraint. Is it appropriate? And if it does occur, as it has occurred, is that appropriate? I'll argue that it is. Rational basis. So under this branch of the test, you need some evidence, okay? But the question that's naughty is what happens when the evidence is uncertain or changing, right? Okay, so that has been ruled on by a few courts. Carissima had mentioned one, I believe, but this is a one from the German Federal Constitutional Court. And in the paper that will be eventually submitted, and that's in progress, there's an English language translation of this decision issued by the German Federal Constitutional Court. So they say that, you know, we accept that where the scientific knowledge is tentative, it's enough to just draw what seem like reliable conclusions at the time. In this case, you have a similar finding by the same court. Moving along, least intrusive means. Now, this raises a distinct challenge. So claimants will argue in these cases, since frontal challenge doesn't work, they'll say there should be an exception to the regime that you have offered, the mobility restriction. And there's a tradition of challenging blanket bans at the European Court of Human Rights, arguing for on exceptionality grounds. Something should be recognized. And there's a distinct risk here because the European Court of Human Rights approach is to say, well, look, so long as the legislators looked at the very issue very carefully, then we will give great weight to that and defer. But in the pandemic context, we are dealing with urgent lawmaking in every case. Is that a liability? I'll just put some of the data that we have. I looked at, in these select countries, at whether or not Parliament had scrutinized the public health regulation before it was made into law. So in no case was there ex ante, that means review of the regulation before it became law for every public health regulation. A very, very, very small number in a couple of countries did get that kind of scrutiny. In 10 of these countries, there was no scrutiny at all. In 19, there was scrutiny after these regulations were made. Does that mean we should follow the line of argument that we just saw and think that there is something wrong with these policies by looking at the process? I would argue no, that is incorrect, and I doubt any court will find that. They will recognize that there is a distinct need for urgent lawmaking to respond to the pandemic. Anyone who doesn't have that view has no idea about how exponential growth works on these diseases. And I can tell you, as someone who's worked in the legislative process in the UK, to pass a new act of parliament properly takes about 6 months. To have a regulation reviewed by the parliament takes usually around 2 or 3 weeks because it has to go before different committees. You can accelerate that, but you're not going to make it fast enough to deal with the risks, the health risks that arise. I'll just mention fair balance and then I'll wrap up. So fair balance stage of the proportionality test can be passed easily when the scales are like this. But what happens as you move from Delta to Omicron? And then a mobility restriction has a tilted scale. So this has come up in the onset of Omicron in Europe. Austria pulled its general vaccine mandate as a result of the introduction of Omicron. Germany maintained its vaccine mandate for healthcare workers under the same circumstances. That was challenged in the Constitutional Court and it was upheld. I would argue that a credible balancing exercise to be used by the judges to start looking at how many people have to die on this side of the scale before you should continue to justify a mobility restriction on this side of the scale. To do that properly, credibly, would require a methodology that Unfortunately, the courts are not in a position to deliver. You'd need something like a quality methodology or something else. I think courts are competent to recognize extreme imbalances, but whenever there's a possibility of reasonable disagreement, I don't think they should go there. I won't go through the remaining slides on judicial restraint. I'll just make two propositions and then I will conclude. The first is that it's widespread, recognized in the courts of the Netherlands, Germany, Britain, Canada, and at the European Court of Human Rights. And I don't think that these judges are abdicating their role as guardians of constitutional rights. They're doing exactly what most of the credible theories of judicial restraint that were pro-human rights and pro-social rights in particular had been calling for. I'll stop there. Thank you.
Thank you, Jeff. We move to the question. We have roughly 17 minutes. The mic is open on the floor and feel free. Please present yourself and ask the question.
So I'm Ray Dionend, and I'm one of the organizers here, epidemiologist here at Ottawa. I have a question for Kumanan. So you mentioned the mucosal vaccines have the greatest potential to stop transmission, but you also talked about the barriers in place to prevent people from wanting to take vaccines in the first place. These are built in demographically and socially. So you haven't got an answer for this, but I'm going to ask you anyway. When the mucosal vaccines do come, how do we get people to take them?
That's a great question. But first of all, not necessarily the optimistic, and many are, but those mucosal vaccines, you saw the AstraZeneca one sort of failed. But let's just say they work. I think the dynamic we're going to see is workplaces are going to be highly incentivized to bring these programs in for economic benefits. They're going to want to keep their workplaces open. They want to protect their workers, obviously, to protect their health. And that's where the battle lines are going to occur. It's going to be in workplaces. The challenge we saw with the mandates through COVID-19 was that the workplaces that would most benefit from the mandates were blue-collar workplaces because they were in warehouses and such, but they were the ones who had the most vaccine-hesitant workforces, and they were also, because of the work shortage, they were reluctant to bring them in. So even though those are the ones that needed to protect their workplace the most, like white-collar workplaces where they could work remotely, we were easily able to bring them in, but people weren't in the offices, so it didn't really seem to matter. But I think that's where we'll see the pressures. It's going to be a sort of a bottom-up approach. I'm not sure if any government's really got the willingness to bring in widespread mandates again.
Go ahead.
Hello, my name is Schwab Bakombo. I'm a third-year PhD student in population health here at the University of Ottawa. I also work as a research coordinator with the Interdisciplinary Center for Black Health here at the university. So I have a question on vaccine hesitancy. It's for anyone to answer. We're conducting a robust research now that's funded by the Public Health Agency of Canada. And preliminary data suggests that there is a tremendous amount of vaccine hesitancy among communities, racialized communities. And a lot of it is because of different, different issues. I mean, there's religious reasons, there is cultural reasons. How do we go about, I won't say convincing, but I'll say, how do we dialogue better with these communities in terms of, showing them that we're on their side when it comes to keeping them healthy without pushing them further away, into this thinking, collective thinking, by and large, on that the state is against us, the whole system is against us. We're not going to take this vaccine. It's meant to, in the case of Black populations, there's a lot of them thinking that it's meant to, castrate or hurt us physically. So how do we go about addressing that for this part? Because I think this is very important in terms of law and public health. So my question is open to everybody.
I'll take the first stab at that. It's not an easy answer. People have been trying to figure out this vaccine hesitancy thing for a while now. A couple of analogies was in the past in Ontario, there'd be these religious communities where there would be vaccine hesitancy and there'd be outbreaks, and public health dealt with it by finding champions within that community. I think that's the most effective way to do this, to come in externally. It creates sort of a cognitive dissonance resolution and a rejection of the messenger. But if you can find a champion within the community who they genuinely believe has the interest of the community at heart, I think that's the most effective way.
Thank you for the question, Shuad. We at Lex Atlas, we put together a group of almost 50 jurists looking at mandatory vaccination. And we have a principle that we adopted, which calls for constructive engagement with vaccine hesitancy. And essentially, the offer there is to recognize that vaccine hesitancy can be reasonable. Whether or not it's rational, that's a different question. It can be reasonable. And it'll be reasonable, especially within communities that have experienced a history of state complicit persecution, discrimination, marginalization, or neglect. And so what we call for in those principles, and I think it's a viable public policy, is constructive engagement with those kinds of that kind of hesitancy. I think that the crackpot hesitancy, I'm not so concerned about constructive engagement with, to be honest. Reasonable vaccine hesitancy, which does exist, and in Britain it is a very serious problem, and it's in social services especially, where there's a disproportionate number of Black and other minority persons who are delivering those services. So constructive engagement doesn't mean you disapply the mandate, but you will have a suite of interventions, one of which would be champions, but others would be cooling off periods, making different forms of advice available, giving people what's called garden leave in the UK, where you can step away from the workplace and take your time to make up your mind. These kinds of interventions. But the concept of reasonable vaccine hesitancy is a way to say, this is a reasonable point of view. The state has to reckon with it.
Thank Carissima.
I don't take issue with anything that's been said. I do just want to take the opportunity to really inject a note of caution. And again, not against anything that was said, but this is a concern I had in the repeated media invocations of this issue, which is that it invariably paints communities with a really broad brush. And we saw some resistance to that in, for example, Indigenous communities, that they thought that it could often be reduced. It was reductive in describing attitudes, and I'm just concerned about perhaps contributing to stereotypes.
We have time for 2 questions.
Hi, my name is Esther Coronado. I work for the Public Health Agency of Canada, but I'm also a scholar in global health. So one of the things that I have seen in all this debate, it's this emphasis on the use of the argument of human rights and human liberties in countries like Canada, the US, all developed countries. However, we are not really looking also at the other issue that in these countries we have access to vaccines. So we have the liberty to decide whether we want it or not. And I think that's an important issue to consider. And I don't know if anybody's thinking about that, in the sense that how now also this argument of human rights is being used by certain groups to defend certain ideologies. And that's a dangerous issue, because the human rights regime has also other sort of implications in the rest of the world as well. So we're seeing a little bit of a conflict in this. So I don't know if you are looking at this part as well, because for one thing is the fact that we have access to vaccines, but we are denying that, whereas other parts in the world, they are looking to have that privilege that we have here. And secondly is that the implications of the dangers of these groups taking over these arguments on human rights and liberties to do things like what we saw here in Ottawa in January, right? To say So what are the implications? What do you think about this? Because I think this is something that may not be of a direct impact, maybe, but it's something that we need to start thinking about because it's really a conflict right now that we are seeing in the world. Thank you.
So,
So the global inequity for the way, sorry, Esther, where I can't see it. They are right. The global inequity of the way that these human rights arguments are deployed is something that is visible, and it's a problem. Access to vaccines is complicated. In COVAX right now, they're having trouble shifting what they have. The issue is at the moment with uptake for a number of reasons, partly vaccine hesitancy, partly because Omicron has made it seem unnecessary. So it is slightly problematic in that respect. In Lex Atlas, we have a huge representation of what used to be called the Global South. And what we've seen there is that human rights law is being used to force governments to act in a lot of cases, in Brazil in particular. That was used. So this narrative that is presented here about liberty restrictions and public health measures, we haven't been seeing happen in that part of the world to the same extent. So I don't think the word human rights is being used in the same kind of way, certainly not being used by people like Bolsonaro that way. So there is clearly a human right to have equitable access to vaccines. That is written into the International Covenant in Article 12. Thanks.
any additional thoughts, Bryan?
A quick thought. I mean, I take the point. Obviously, it's an important issue. I do think that there have some of the commentary on vaccine passports has tried to link these two issues, and I find that kind of specious. I mean, the people saying, well, you know, until everybody in the world has access to vaccines, then we shouldn't have vaccine passports in Canada. And I just think that's a total non sequitur, right? You know, the alternative. I mean, first of all, it just doesn't make any sense, right? We can have a domestic policy and separately address the problem of access in other countries, and holding off on the implementation of it wouldn't benefit anyone for us to have held off on the implementation of vaccines in Canada or vaccine passports in Canada, pending their availability everywhere in the world. It's just it doesn't make sense as far as I can tell by kind of utilitarian logic.
We still have 5 minutes, 6 minutes left. We should have time for both questions.
Sure. Very quick response to the question of how to address reasonable vaccine hesitancy. And what we're hearing on the ground from community members is that it's going to take time to build trust, to show me that you actually have my interests in mind. And so it's a bigger project to actually be fair in how we support everyone in the community. So that's what I was thinking there. But what I wanted to understand is, how do you make this analysis clearer to the majority of the population that thinks there have been violations of human rights? Like you said, Bryan, this was known, this analysis could have been done within a month, you know, a year ago.
Yeah.
So what's the next step to be able to influence public opinion to bring this out of the compendiums into common assessment?
Yeah, I don't know. I mean, I guess in the paper, I'm sort of going after some people in sort of philosophy departments and law faculties who I think have just talked about this topic a little bit irresponsibly. And I'm trying to just make the point that, you know, you can't just play footsie with these topics for months on end while during an emergency, right? But by a month into this, you should have had a position on this, and it shouldn't be just, I think there are things we should look at and blah, blah, blah. You know, it's like, do you think this is a good or a bad idea? Let's get an answer on this, because time's of the essence here. So that's kind of the focus in the paper. I'm just not a PR person or whatever the expertise would be on how to sort of train the public better on understanding these things. I think it's a ubiquitous problem that people do tend to think of rights in terms of the kind of Trump model, right, versus the Canadians just aren't as familiar as they should be with the idea of proportionality and analysis, right? And so that there's an education problem there. But I guess that would be a long-term project to fix, or problem to fix. Others' thoughts?
Can I just say a word about that? The public has been broadly supportive of these public health interventions in the UK, and there's been a disproportionately loud voices on Twitter that have been conveying something else. So I think there's been a perception amongst politicians they don't have to engage that much about this because people get it. That's been the case in the UK, at least. And that's a liberal culture that they have there. So, but I think what you need to do, what you just asked about, is to have leadership from the top of the political parties to explain to the public that that it's crazy to think a right to liberty means you can give somebody else a fatal disease, and that you don't have to take any precautions to stop that. I think a grown-up discussion could be had, but maybe I'm being optimistic.
If I could just add something, please. Sorry, I've been trying to get in. I just have a couple of comments. The first is with respect to the human rights framework. I think there's a conceptual distinction between the human rights framework and the civil liberties framework. I mean, the human rights framework in Canada is essentially grounded in a particular vision of equality that has historically been quite distinct from the civil liberties framework. And it's really the civil liberties framework that is motivating a lot of the opposition that we've seen. And the other thing I just wanted to inject in here is we have to keep in mind also when we think about public response, the impact of practical politics and the federal provincial divides and partisan divides and how a lot of this really does boil down to, in some cases, opportunistic political positioning by certain political actors against other political actors.
We have 1 minute left.
Oh, okay.
Should be time.
I was actually going to make a similar point to Carissima, but I was also wondering, Jeff, and the whole panel, that was amazing and really insightful and helpful, I think, for the conversations that we have to have. But we were debating yesterday some, and we'll be debating later on around the revision of the international health regulations. And, you know, the current sort of protection that's baked in there now for travel and trade, you know, that any kind of public health measure can't adversely impact travel or trade. And you know, as I think about that, I think when people defend that, implicit in their defense is some sort of assumptions about the rights that are bundled into sort of travel and trade. And I just wondered what your guys, in particular Jeff, but others, what your thinking is on that, if you've had a look at that at all, and whether, you know, is it sort of an individual right to mobility that is kind of captured within that? Is that what the problem is, or is this really about economic rights and so on? So.
I don't want to pretend I have a deeper view on this than I have, because I haven't looked. I think it's important that I would look at the international health regulations in greater depth. But what I can say is that the international mobility of persons is not just for tourism, but there's a huge amount of cross-border employee movement. And insofar as the right to work is engaged in some way or another, it doesn't mean that they have a subjectively assertable right to work in a foreign country, but the reality is that there are many migrant workers who are exercising human rights, and these can be interfered with. And I think, you know, in the China report, it mentioned, I think there are something like 300,000 people moving around within China a year. They're working in places other than where they live, and they have to migrate in the country. And these can be, think about 300 million. That's what I meant to say, 300 million. We're talking about an enormous number of people. And then there's all sorts of groups, and not just, I mean, not just sort of movement of domestic workers, although that's a huge category, but a slew of different categories. So I think that there is a way of looking at that as a genuine human rights issue. Trade, I'm loath to recognize economic interests in human rights terms, but the fact is that trade is linked to the provision of goods which can fulfill human rights. And it's linked to the state's capacity to, through taxation and economic competent resources, to fulfill its human rights obligations, which in the time of a pandemic are hard to fulfill, because social policy is a massive part of the pandemic response.
30 seconds.
Just, I think Sam and Steve are be much more knowledgeable on this, but I think unnecessary interference with international travel and trade and so that the WHO will set the standard and countries can exceed, but they have to provide public health justification, based on the situation within their borders. I think it is a difficult tension and a hard one to resolve when the science is so uncertain at the outsets. And this is, I know we've all used the term precautionary principle, and I've been an advocate before, but it's an easy word to use, but it's hard to actually operationalize, because if we're always acting on potential, then it does allow us to do basically anything. So